At Investigation Counsel PC, we're Canada's only boutique law firm focused exclusively on fraud recovery. We act for victims, not fraudsters, and we litigate civil fraud cases every single day. Whether it's Ponzi schemes, misappropriation of funds, or corporate fraud, we help victims trace and recover their assets using powerful civil remedies, including Mareva injunctions and Norwich orders. One recent court decision shows just how seriously courts take compliance with those orders. In Tabrizi v. Farjami, over 24 million Canadian dollars was allegedly invested in a business called Trip Support, a book-now, pay-later airline ticket financing platform. The plaintiffs claim it was a Ponzi scheme, and they sought urgent civil remedies to protect their ability to recover. In September 2024, they obtained a Mareva injunction, a court order that freezes a defendant's assets, and a Norwich order to trace the flow of funds. But when the defendants were served with the court orders, they denied under oath that they had any assets outside Ontario. That turned out to be false. Later, title records revealed that they owned property in Spain. Even their own lawyer admitted they had failed to comply with the Mareva injunction's disclosure requirements. As a result, the Ontario Superior Court found Vahid Farjami and Leila Olyai in civil contempt of court. Sentencing will be determined at a later hearing. However, and this is where it gets interesting, the court also set aside the Mareva injunction. Why? Because the plaintiffs failed to make full and fair disclosure when they applied for the order without notice to the defendants, a key requirement in ex parte motions. The court listed several material non-disclosures, including that some plaintiffs were paid commissions to recruit new investors, that over 3 million Canadian dollars had already been repaid, that the actual amount lost might only be around $6 million, not 24, and that Farjami had claimed the money was invested in real estate in an effort to recover losses. The judge emphasized that this lack of transparency could have influenced whether such a broad asset freeze was granted. Still, and this is critical, the court ruled that setting aside the Mareva injunction did not invalidate the contempt proceedings. Why? Because contempt is about what happened while the order was in place, not whether the order is later overturned. In other words, violating a court order still has consequences, even if that order no longer stands. This case is a strong reminder. Courts will not tolerate parties who ignore asset disclosure obligations, especially in fraud recovery litigation. At Investigation Counsel PC, we help victims pursue justice through the civil system, often faster and more effectively than through the criminal courts. If you've suffered financial loss due to fraud, don't delay. Reach out to us before alerting the fraudster or contacting police. We'll assess your case and develop a clear legal strategy to help recover what was lost. Visit investigationcounsel.com and let us help you take the first step toward justice.